Intellectual property law. Intellectual property, or IP, is a form of intangible creation such as the expression of an idea or a trademark. It is a product of intellectual effort rather than a physical manufacturing process. In earlier topics, when we have referred to goods or property, for example in topic 4 when we talked about trespass to goods, or in topics 5 and 6 when we talked about the sale of goods, or in topic 7 when we talked about the rights of a consumer when buying goods. In all of these cases, we assumed that the goods that we were talking about were tangible, physical goods: cars, computers, items of clothing, items of food. For example, if you take my computer without my permission, you commit the tort of trespass to goods, and I will have a clear legal remedy. In this topic, we consider the ways in which an owner's rights over intangible items of property are protected. These intangible items of property include stories, works of art, brands, logos, inventions, recipes, commercial secrets. Intellectual property law grants a business the right to prevent others from copying or using or exploiting its intellectual property without its permission. Intellectual property is a valuable commercial asset. Items of intellectual property such as movies or brands can be worth millions and millions of dollars. The owner of intellectual property has the exclusive right to exploit the intellectual property for a profit. They also have the right to license the intellectual property. In return for a fee, the owner of the intellectual property permits others to exercise their exclusive rights in relation to the intellectual property. Different aspects of a particular product may be protected by different types of intellectual property law. For example, with a can of soft drink, the textual information written upon the can will be protected by copyright law. The name of the product and its logo will be protected by trademark law. The actual manufacturing process may be protected by patent law, and the recipe for the product may be protected as a commercial secret. Each of these different types of intellectual property law developed independently and are characterized by different principles and different specific rules. Some of these protections are automatic. Others will only come into existence upon registration of the particular form of intellectual property. Some of these are regulated by legislation. Others are regulated by a combination of legislation and case law, and still others are regulated solely by case law. Some forms of intellectual property protection are only for a fixed period and then expire, after which the intellectual property enters the public domain and becomes usable by anyone. Other forms of intellectual property protection can potentially last forever. And the different types of intellectual property protection can overlap. Software, for example, is protected by both copyright law and patent law. In the following videos, we will consider each of these 4 types of intellectual property protection in turn.